Good afternoon. Hello. Hello, ladies and gentlemen. I'm Corleen Kraft. I'm President-elect of City Club, and welcome all of you today to our Friday Forum. We're continuing today our State of series. Those of you who are familiar with City Club know that we have State of the State, State of the City, State of the Port, and today Presiding Judge Dale Koch will be talking about the state of justice, primarily in Multnomah County, but also throughout the state of Oregon. Next week, continuing with the theme, Chairperson Diane Lynn of Multnomah County will be talking to us about the state of Multnomah County here at the Mac Club, so we'll be looking forward to seeing you then. Judge Koch today will be helping us take some of the mystery out of what's going on behind the scenes, at least behind the scenes to those of us who are not familiar with the court system in Multnomah County. And Nikki Lynch, who's a senior financial advisor for Merrill Lynch, will be our board host today. We want to specifically thank our sponsors who underwrite our broadcasting. Without them, we would probably not be able to spread the word throughout the state of all the Friday forums, and we hear from people all over the state telling us how much they appreciate the information that the City Club is able to provide. So our corporate sponsors are the Weyerhaeuser Company Foundation, Legacy Health Systems, and Wells Fargo Bank. Our big thanks to them. Dale Koch could probably be described as Tom Mccall's kind of Oregonian. He was born in Oregon, and he went to college here, graduated from University of Oregon Law School, and has stayed in Oregon. He was a deputy DA in Multnomah County for a number of years before going into private practice. And in private practice, he, for the last 10 years, focused on family law. He's known around the country, he speaks around the country on issues of family law, teaches continuing legal education, and has recently ascended to the position of presiding judge of Multnomah County. I give you Dale Koch.
I really want to thank the City Club for the invitation to address this group here today. It's really a unique opportunity on behalf of the court system and the justice system here in Multnomah County and the state of Oregon to be able to address this group. My wife's going to be real excited to hear my name and Tom Mccall's name used in the same sense, I can tell you that. I'm the presiding judge in Multnomah County, and what that really means is I'm the chief administrative judge for the county. People have described it as I'm the chief cat herder because the 38 judges in our county are all independently elected officials. I was appointed to this position by the Chief Justice of the Supreme Court, who is in essence the chief administrative officer for the court. He's the CEO for the court system in Multnomah County for the judicial branch of government. I don't know whether it was ominous that that appointment started the 1st of April of last year, but it sure has turned out to be true. And when I was thinking about what day it was I was addressing this group, I got another shiver, this being Friday the 13th. But let me just talk a little bit about the structure of the court system here in Multnomah County and the structure of the court system statewide. I know a number of you are very familiar with that. I've got a former Supreme Court Justice here today. I've got present Court of Appeals Justice here today, and a number of attorneys. And I know you're familiar with that system, but let me just talk to you a little bit about how the system is set up, and maybe that'll put into perspective the issues that we've been facing over the last year and a half. Here in Multnomah County, we have 38 elected judges, as I indicated. An interesting mix. At this point, we have 20 men and 18 women who serve as elected circuit court judges in this county. And if you'd look back not very many years ago, you'd find that mix to be considerably different than it is today. Some of the judges came on the bench by way of election. Some have gone through a contested election process. Others, such as myself, came on to fill a vacancy of a judge who retired, and I was appointed originally to fill that vacancy by Governor Roberts, and then I've run for election twice since then, fortunately without an opponent. We also have pro tem judges that we use here in Multnomah County and are used in some other counties in the state because we just do not have enough elected judges to handle the caseload that we have. That's been recognized by a number of studies, even recognized by the legislature, because they have, in the past, at least, funded some of these referee positions for us. We've had, at least we did, January 1 of last year, had 12 and a half referees. We are now down to 9 because, again, as part of the budget process, as we've had referees either retire or, in the case of 2 of the referees, get elected to the bench, as elected judges, we've just left those positions vacant. Statewide, the system is set up where we have 7 justices in the Supreme Court in this state. Again, they come on the bench in the same way that the trial court judges do. We have 10 justices in the Court of Appeals and 1 tax court judge. Statewide, as I said, we have 38 judges here, but there are now 169 circuit judges elected throughout the state in 27 different judicial districts. For some of us, like in Multnomah County, Clackamas, Washington counties, the county is the judicial district. And if you get out into some of the more rural parts of the state, it may be as many as 4 or 5 counties in the same judicial district with a number of judges, or you could be like Judge Kramer is over in Grant-Harney County, where he covers, 1 circuit judge covers all of Grant and Harney counties. And any of you who've been over there understand that that's larger than some states in our union. So the Oregon system, the way our courts are designed here at this point is a very unique system. And that has made us, through the years, a very efficient system, and one where justice gets done in a prompt fashion and I think gets done effectively. Through a series of legislative changes, the trial court system in the state of Oregon has become a single-level trial court. We no longer, I originally came on the bench as a district court judge, and they deal with misdemeanors and smaller civil cases and matters like that. Although from the very beginning, I ended up sitting in the family court, which theoretically was a circuit court function. And the decision was made that it was just more effective use of our judicial resources to have 1 level of trial court. So that's what we have. Whether you start with a misdemeanor or you go up to a capital murder case, those are all going to be heard in the same court system. One of the advantages of that is it just requires 1 hearing for a lot of things that used to require 2. Here in Multnomah County, we also have an additional wrinkle to that, and that is that we are also the municipal court for the city of Portland and the municipal court for the city of Gresham, the 4th largest city in this state. And that is a model that you will not find in any other place in this country. There's no other place in this country where the same judge can be hearing a parking tag citation 1 minute and turn around and have the next case walk into his case to be his courtroom, a termination of parental rights case or a murder case. That provides a lot of variety for our judges, but also provides a lot of efficiency for us. And one of the things that is also created for us is a mix of work that has created, I think, judges who have much more job satisfaction than people that I've talked to in other parts of the country that get stuck into little niches that they can't get out of. The one exception that we've made here in our county is that we have a separate family court. We have 9 judges who sit in that family court, together with some referees who sit in that court. We presently have 3.5 referees sitting in the family court. And they deal with the domestic relations cases, quite a bit of the domestic violence docket, and they deal with the child abuse and neglect cases, and they deal with the juvenile delinquency cases and the probate cases. We're unique in that regard as well, in that all 9 of those judges who sit in our family court are sitting there on a voluntary basis. In other words, they all opted in to sitting as a family court judge. That's what I did when I was on the bench until I took over as presiding judge. And that is really unique, because if you look around at other parts of the country and you talk to people that have tried to develop these types of systems, the first question you always get asked is, well, how long do the judges have to serve there? Do they go there for a year, and can they get out after a year? Can they get out after 2 years? How do you get people to stay there? And we have a unique system here and a unique group of judges, and I attribute some of that really to the method in which judges come on the bench by appointment to fill vacancies in allowing us to operate in that kind of system. I'll give you just a few more numbers, and then we'll talk a little bit about some of the things that are going on in our courts. Here in Multnomah County, we did operate out of 7 separate locations. There are 40 courtrooms in the courthouse downtown that was originally designed and built for 17 courtrooms about going on 90 years ago, a little over 90 years ago. There's a courtroom out in Gresham, and out there we run a courtroom both during the day and a night court out there. We have a judge who's over in the Portland building where we do settlement conferences on a full-time basis over there. The Justice Center, which is the main county jail downtown, also has 4 courtrooms in it. So we have 4 judges over there, at least we did. And the Juvenile Justice Center, which you might see along the freeway out about 68th and Halsey, are where most of the juvenile matters are heard. We have 6 courtrooms out there. And then we were running community court operations at both the King Center over in northeast Portland and at the Darlington Center out in southeast Portland. Both of those operations are closed at this point in time because of budget issues. It is our hope that we're going to be able to reopen those operations. Fortunately, with the passage of 2648 here in Multnomah County, the county income tax, that's going to provide the funding to let the district attorney and the sheriff fund those operations, and some money for the Department of Community Justice to assist in that operation. So if we can get the court operations piece of it, we'll be back in those community courts. Now, I've talked to you about how many judges we have. Let me give you an idea just briefly about how many cases that are going through this system here in the state of Oregon. Total, excluding the parking tags, and I'll talk about that in just one second, there are around 650,000 cases that get filed in the state court system every year. About a little over 205,000 of those cases get filed here in Multnomah County. And just think about that number for a second. Even if those cases don't take a whole lot of time, let's assume it's something as simple as a speeding violation. That's a piece of paper that ends up getting processed a number of times. A lot of entries get made, and that's our staff that we rely upon to do those. And that's what's really hurt us as we've gone through this budget reduction. We are also, as I indicated earlier, unique in the sense that we're the municipal court for the city of Portland, which adds another, and all of you probably have contributed to this at one time or the other. I know I have another 350,000 parking citations that get filed in our court every year. Now, the court, let me just take a step back and talk a little bit about what happens with the monies that get collected from those citations and from the violations. Here in Multnomah County, it takes us, our operational budget runs around $20 million a year for the court operations. We end up collecting we'll collect about $33 million per calendar year over the terms of the last biennium. That money doesn't go to the court. There's a clear separation for obvious reasons. We all remember the stories about the speed traps in the old days where the judge financed his staff and his vacation and his office by the fines that he could impose on the people that would get stopped in whatever that local jurisdiction might have been. So there's a good reason why you want to separate the people that are administering the justice from the money. So what ends up happening with the money that gets collected by the courts here for various things, filing fees and fines and other things like that, some of the money goes to the city of Portland, They get reimbursed for the citations, that, for a portion of the money on the citations they issue. And then some of the money goes to the county and to various municipalities, and then the bulk of the money, slightly more than half the money, ultimately ends up in the state general fund coffers. And then we hope we can convince the legislature that they need to fund us from those same coffers. Oftentimes there's a disconnect between those two, and we try to reestablish to them as often as we can that we doesn't really cost us the entire cost of the operations that they attribute to us, that we actually do collect some money back the other direction. Here in Multnomah County, the cases that are going on, there are about 8,000 felony cases that are filed each year. About 12,000, over 12,000 misdemeanor cases that are filed each year. 25,000 civil cases, and those range anywhere from small claims court actions that some of you may have participated in, landlord-tenant actions, personal injury, contract, professional negligence, up through wrongful death actions, and those are all in that group. We also are much more involved in the domestic violence area than we ever were in the past, and we have about 3,500 abuse prevention restraining orders, both for domestic violence and elder abuse prevention restraining orders that we get filed here and that we deal with on an annual basis. And we have about, unfortunately, over 1,000 petitions that get filed every year out in the juvenile court regarding children who have been abused and neglected by their parents or caretakers. And the numbers are now around 300 to 350 of those ultimately end up in petitions that are filed to seek the parents' parental rights and to try to assist in getting another permanent home for those children. Which is, by the way, the only kind of case I still do. When I took over as the administrative judge, then I end up with a lot of administrative functions, and I do not carry an active caseload other than the child abuse and neglect cases that I had when I was sitting as a trial judge. And that's part of the model that we've had here, that we're going to have one judge follow that family from the time they enter the system until the time they exit the system, whether that's by return to the parents or whether it's by termination of the parents' parental rights, to try to provide consistency and responsibility to the system. Now, the justice system has a couple of ways it can operate. It can operate in a system where we sit back and we let the cases come to us, and we throw up barriers to people getting to court, and we throw up barriers to people entering the system, and then if they kind of get past those hurdles, then we sit up on the bench and we call the balls and strikes and send them away. And in many places that's been the way that justice has been administered for a long time. In Oregon, there's always been an effort to look at things differently, as we know sitting around this room. And the goals of the justice system here, among those goals, have to be improving access to the justice system. You don't have a true justice system unless everyone has the ability to access that system, regardless of their financial resources, regardless of what they look like, regardless of any of their preferences. You need a system where people have the ability to access that system, to have a justice system. And you have to look at the outcomes. I mean, it's kind of like the doctor, the idea about the doctor doing no harm. It's the same concept for the justice system. It's if people are going to come through and be worse off than when they started, why are they coming through the system to begin with? We need to be looking at the outcomes, and so that has been the goal for the court system, which is to provide that access, and then really to also make sure that we are all taking, as participants in that system, whether we're judges or prosecutors or probation officers, that we are improving the bottom line outcome. There's a quote that's on the Justice Center that has struck me as we've been going through this process, and I've read, that comes from George Washington, and assuming that they have engrave the correct quote on the building. It is that the due administration of justice is the firmest pillar of good government. And that's what we need to strive for and continue to strive for. We've done a lot of things through the years in an effort to meet those goals. We've learned those things from each other. We learned them from other states. We even learned some things from some other countries. We have a mediation system set up here that requires anybody in a domestic relations case where there are children involved to go through mediation before they can come to court. We have a system in juvenile dependency cases where before we're proceeding to a termination of parental rights trial, again, we're trying to mediate a result that is really in everyone's best interests. Small claims court, FED cases, again, the day of the hearing, we have mediators there to try to mediate that dispute in a recognition that people should be solving their own problems instead of having a solution imposed upon them by others. Settlement conferences. Judge Lamar was one of the first judges in the country to become a judge devoted to doing just settlement conferences. Has been doing that for several years and has continues to operate that, resolving numbers of cases for us. We also have private mediators, private judges who are doing settlement conferences on that same basis. Multnomah County is a model dependency court. We have some participate as one of a number of model dependency courts around the country, funded by the Office of Juvenile Justice and Delinquency Prevention, federal office. Finally, a recognition from the federal government that if you deal with children when they're in the dependency system, that really does serve a purpose of reducing juvenile delinquency in the long run. So we have been one of those courts, and one of the models that we have spread to other places in the country is this model of the one judge, one family model for kids in foster care. Domestic violence. The model domestic violence code that was used around the country to develop statutory model codes for domestic violence came from the state of Oregon. If you look at the Oregon Revised Statute and look at the code in a number of other states, you'll see almost exactly the same wording. That came out of the state of Oregon. And we've got a deferred sentencing program, which is that we use for defendants in domestic violence cases that really relies upon, one, there is a carrot that their case will in fact get dismissed. But what there is that makes it really work is intensive supervision of defendants who are involved in domestic violence cases. Unfortunately, that takes resources, but if you don't have that, you might as well not be going through the process. We have the DIS program, which is intensive supervision for people that have multiple DWI offenses, drunk driving offenses. We have drug courts. There are now, I was looking the other day, approximately 800 drug courts in this country. The second drug court that started in this country was here in Portland, Oregon, and we continue to operate that drug court today. We are struggling with issues regarding the funding of treatment, which is a vital component of the drug courts. But we've also recognized that we were having some people that were opting out of the drug court option because it was better for them to go to trial, get convicted, and get put on probation. So we've created a second drug court that now says, well, if you go through that option, you come right back into us, and we're going to treat you just like if you'd opted out into the drug treatment court in the first place. Because why are we doing that? Because the treatment is effective. The study, recent study was done that shows for every dollar that we spend in a drug court, we save $2.50 in direct costs and $10 in indirect costs. And direct costs are things like the supervision and the future and other arrests and items like that. We also now have a drug court for juvenile delinquents, and we've used that same model now for parents who come through the child dependency system where their problem is primarily substance abuse, and I can assure you that most of the parents who come through the system where their children are taken away from them, or we're looking at taking their children away from them, the issue is substance abuse. That brings me to one thing that is really at the forefront right now, or at least moving to the forefront, and that is examining what works. Taking a look at, there are things that we do in the criminal justice system that intuitively seem like they should work. There are things in the criminal justice system that, quite frankly, from the judge's perspective, make me feel good. It makes me feel good sometimes when I have somebody in front of me who's a real jerk putting them in jail. And it probably feels good to make them, put them in jail for 60 days. You know, I'm fed up with you. You're creating more trouble for me than I want to put up with. The reality may be that it's fine for me to feel good, but what I should be looking at is if I put them in jail for 10 days, if they're going to be a better outcome than if I put them in jail for 60 days. And the reality is, in most cases, that's going to be the situation. Once I get beyond 10 days, then I start cutting out the support systems for that person so that when they get back out again, they're more likely to commit another crime. And that should be my goal as a judge, not to make me feel good or the probation officer or the DA, but it should be to make sure that I reduce the chances that somebody else is the victim of the same person in the future. So Judge Marcus is doing, in our court, is doing work that is known throughout the world, really, at this point, in terms of focusing us in on those issues. We've had case disposition standards in this state for several years, and I was a trial lawyer when these case disposition standards first came in, and I objected to them. What do you mean telling me I've got to have my divorce case to trial in 270 days? What do you mean I have to have my civil case to trial in a year? What do you mean we have to have that criminal case to trial in 120 days? That doesn't give me enough time to do that. And I think that was pretty much the feeling of the trial lawyers at that time. But that was imposed upon us by the court system. And I think all of us who've operated with those case disposition standards understand at this point that those have been very positive, not only for our court system, but for our community. The old saying about justice delayed is justice denied is just not an old saying. That just didn't come out of the blue. That's really true. And so now we have those case disposition standards where if a defendant's in custody, we need to take that case to trial within 60 days. Out of custody within 120 days. Termination of parental rights cases to trial within 180 days. As I said, the domestic relations cases, 270 days. And this doesn't, in terms of going back to the criminal cases for a second, that just doesn't work in terms of the defendant. You know, yes, we're protecting a defendant's right not to be held in custody an inordinate amount of time before they go to trial, but the person that really affects is the victim. It's the victim that wants to move forward and get that case resolved in a timely fashion. Unfortunately, at this point, the civil trial standards, that we're sticking with the criminal trial standards, but again, because of some reductions, we're not holding quite as tight as we were to the civil standards. Community courts. I mentioned earlier we had community courts out in Darlington, the Darlington Center, and over to Martin Luther King Center. Those courts, and again, we weren't the first to do that. We went someplace else and looked and said, hey, this works, and we brought it back here, and it works. But we are now a place that people come and look at and say, hey, this does work. It deals with low-level offenders, basically people with misdemeanors that are some treated as misdemeanors and some as violations. It provides a swift resolution of the case. The idea is the first time there or the second time they're in court, that case gets resolved at a cost savings to all of us. It gets one of the primary components of it is that the offenders are doing community service, not just in the county as a whole, but in the community where they committed the crime. So if somebody was out in Southeast, going through the court at the Darlington Center, that's where they do their community court, their community services out in that location. So we started the Northeast Court with some federal funds in 1998, the Southeast Court, and then the court over in the West Side Court, which is at the Justice Center downtown, started in 2001. And since those courts started, we've now had over 4,500 criminal defendants go through there, performing more than 66,000 hours of community service. That's paying back to the community for their conduct. Facilitation centers. That's something that that we were able to convince the legislature was a good idea a couple of years ago. Here in Multnomah County, we copied the model from Marion County. Marion County, I think, copied the model from a county in California. The idea is that in domestic relations cases, well more than half of the people that come through the justice system in a domestic relations matter are representing themselves. Now, some of those people are representing themselves because they just don't trust lawyers. I recognize that. But most of those people are representing themselves because they can't afford to hire a lawyer. They can't afford the $150 an hour or whatever it's going to cost them to hire a lawyer to assist them with their problem. And what was happening is they were trying to muddle their way through the system by themselves, usually with a lot of frustration and not much ultimate success. So the facilitation centers were set up in a number of counties, including here in Multnomah County, and originally through a combination of some state money and some county money out of the Family Services Department. Those facilitation centers are now responding to over 1,000 inquiries a month. It's 1,000 people a month are contacting the facilitation center on domestic relations cases seeking some assistance. At this point, I've been talking with a local law firm, not about the domestic relations facilitation centers, but just in recognition that a lot of civil litigants are now trying to represent themselves somewhat equally unsuccessfully, and we're going to try to create a volunteer organization to try to provide them some assistance as well. Okay, what's happened? Starting in the spring of 2002, the system started to come apart. As you all know, the legislature went through 5, and some say 6, special sessions, none of which were designed to add resources back to any of our budgets. The county was going through its own budget crisis during that same period of time. Statewide, we ended up losing $21 million in funding for court operations, another $22 million in funding for indigent defense. We were seeing cuts where there had been 175 jail beds closed in this county as a result of their funding crisis, including the Work Release Center, which allowed defendants to, while they were serving their sanction, so they were in custody, allow them to continue to work so that they could pay their support obligations and other financial obligations. We lost 13 deputy district attorneys. That was over 10% of the deputy district attorneys in this county. That's the prosecutors in the courtroom handling that criminal case. Over 60 staff positions at the Department of Community Justice. That resulted, among other things, the closing of an inpatient substance abuse treatment program. Mental health and substance abuse treatment dollars were going away. And we were slowly shutting down our operations. And really what was happening was really a breakdown of the entire criminal justice system. Our society works on the rule of law. We might disagree with the rule, we might disagree with the ruling, but we work on the rule of law. If you have a dispute, there's a justice system, you go through that justice system, that resolves your dispute. Heck, I disagree with some of the Supreme Court decisions, but they get the last say, I don't. And if you look at what goes on, what's going on in a country like Iraq right now, one of the first things they're trying to establish over there is a rule of law. So people have a justice system instead of resolving disputes amongst themselves, usually with violence. And that system was breaking down. Starting the 1st of March of this year, after we took the last of those cuts, we were down 30% of our staff. Those people that are processing those 900,000 cases that go through the court system on an annual basis, we had 30% less of those people to do those cases. We had eliminated all of our court reporter positions. We had, in Multnomah County, eliminated 80 staff positions out of 330 positions. As a result of that, and the staff that was remaining were furloughed 1 day a week. This is the day, if you go to the courthouse, other than judges doing settlement conferences and meetings, you'll find that the courthouse is vacant because it's closed. We stopped being able to process large numbers of criminal cases. The estimate is there will be approximately 25,000 criminal cases where someone was arrested between the 1st of March and the 1st of July where that case was not able to be processed because we were not able to provide counsel to those defendants. Cases included bad check cases, credit card fraud cases, mail fraud cases, prostitution, shoplifting, trespass, vandalism cases. All of those types of cases stopped being able to be processed through the criminal justice system during that period of time, and we're still in that situation right now. We are hopeful that post-July 1, that the situation will improve. The legislature, as you know, is in session right now. The Chief Justice has proposed a budget that would allow us to bring operations back on a 5-day-a-week basis and continue and begin processing the cases that we had not been able to deal with before. And we're going to have some new cases coming in because crime hasn't stopped. And in fact, unfortunately, over the last few months, the statistics from the Portland Police Bureau and others indicate that since about the 1st of the year, the crime statistics are going up significantly, particularly on these types of crimes that we were not able to process. The budgets proposed by the governor and the co-chairs of Ways and Means are both significantly less than the chief's proposal. In fact, if those budgets were adopted, we would take further cuts. We wouldn't be talking about restorations. But on a positive note, I think there are negotiations going on, at least I heard it on NPR the other day, down in Salem that would indicate that there is hope of adding back sufficient funds to both indigent defense, to the court system, and thankfully we've had we're going to be able to have some local add backs as a result of 2648 to allow us to begin again operating as a full-service court system. We've learned some things going through this process. I think we have created some efficiencies that we're going to continue to keep in place even after we go back to an operation, because we're not going to get back to the budget we were at 2 years ago. We all recognize that. We're going to have to deal with the several thousand cases that are in our what they're calling the bulge right now. We're going to get back to a 5-day, as I said, a 5-day-a-week operation the 1st of July. And then at that point, hopefully provide to everyone both the civil and criminal justice system that you have come to expect in this state. I do want to thank, again, before I take questions, I do want to thank everyone again for an opportunity to address this group about an issue that is obviously, as you can tell, very close to my heart, having worked as a lawyer in this community since 1972 and having lived in the state my entire life. So, thank you.
Thank you, Judge Koch. gosh, very enlightening. We come now to the question and answer period of our program. One of the many privileges of City Club membership is that the members only are allowed to ask questions, and I would like to remind everyone that those questions should be posed in 30 seconds or less. Nikki Lynch, who's a member of the Board of Governors and our new program committee chair, has the privilege of asking the first question, but please begin to line up behind the microphone here to ask your questions when Nikki has finished. Thanks.
Well, just as I thought, you answered lots of the questions I had, but one that came up in you're talking about sentencing people 10 days versus 60 days and that sort of thing. I wonder how much discretion or how much you're caught up and hobbled by the mandatory sentencing that I assume is still in place, unless I'm just playing my ears. Thanks.
Thank you. I think you're probably generally referring to what's called Measure 11 sentences, and that is, as most of you know, a series of crimes where the court is mandated to impose a minimum sentence. The sentence is beginning, depending upon the level of the crime, for something like a robbery in second degree of 70 months on up. Beyond that, what that has done is shifted the discretion. The court used to have the discretion to impose the sentence based upon sentencing guidelines for all types of crimes. That discretion has now shifted from the judicial branch to the executive branch. That discretion has shifted to the district attorney's office. And in some counties, that still works pretty well, where the district attorney's office takes a nice objective look at the situation, and I think for the most part there isn't a lot of complaint about where they end up. It does put an awful lot of pressure on the defendant in terms of the plea negotiations if they want the district attorney to make a recommendation in terms of accepting a particular plea. But that's where that discretion is shifted. In some other jurisdictions, I think that there's strong disagreement about how well that is working.
George Van Humison, member of the City Club. Judge, my question relates to the county courthouse. And in terms of priorities, it may not be the top priority when you're closing the courts 20% of the time, laying off DAs, closing jails, and so forth. But about 1962 or so, there was a movement to build a new county courthouse. County Commissioner David Eccles was behind that. And Dave Eccles got that measure put on the ballot. It was to build a justice center down around where the county courthouse is now. That measure almost passed. I assume it was a bonding measure. It almost passed. It was defeated by less than 5%. My memory is about 2%. What's the latest report on the possibility of getting a new county courthouse? I think the one you have, the first time we get a 0.6 earthquake, the whole thing is going to come down around your ears.
There have been a number of studies, I think the better part of a dozen studies that have been done in Multnomah County dating back into the 1950s regarding the courthouse situation. The Richmond Courthouse was built in 1912 with a 40-year life. It had 17 courtrooms in it. As I indicated, we now have 38 courtrooms in that building. Floors have been chopped up and cut in half, so they're only half as high as they were before to create that. The studies have indicated that the building is, I think at this point, the least safe public building in the city in terms of its structural stability. At this point, and we have, I think I was looking the other day, we have about 3,000 people come in and out of that building every day. So if we have a problem there, it's not going to just be with the employees that work in the building. There's been and as Justice Van Humison indicated, it is very earthquake prone at this point. there's a history of this in the state. Just a few years ago, there was an earthquake in Klamath Falls in a building that was much more structurally sound than ours that ended up closing that building, and they ended up spreading their courts throughout the county. They had a much smaller operation than we have, and were able to do that with much grief, but they were able to do that. If we had that same thing happen here where we closed down the courthouse, I'm not sure where we would go. In response to what's the latest word, Chair Lynn, and she's going to be here next week addressing this organization, has a steering committee that's been working on the issue of whether we could remodel the current courthouse or whether we needed to build a new courthouse, and concluded for lots of reasons that building a new courthouse was the only option. It's probably the right answer at, unfortunately, the wrong time in terms of what's going on financially in the county and the state. But it's something that we need to put on at least on the medium burner and be moving forward with. Otherwise, we are going to find ourselves in a catastrophic situation at some point where our court system shuts down, not for lack of funding, but for lack of facility.
Bill Savage, City Club member, Judge Koch, I appreciate your concern about the outcomes and your work with domestic violence and family law. And I wonder if you wouldn't mind sharing a story or two with us of outcomes that you feel have been particularly positive. Because I think the bench can make a huge difference in the impact.
Well, I'll share just one story, and I'll share it very briefly, and it's in the juvenile dependency area, just because it's my most current story, I guess. As I said earlier, the judges who are doing child abuse and neglect cases, we pick up those cases, try to pick them up at the initial shelter hearing. And in Oregon, if a child's removed from a parent, there has to be an initial shelter hearing within 24 hours of removal. If we don't get it at that hearing, then we set another hearing within 7 days and get it to that judge who's going to have the case from then until that case concludes. I had a case yesterday that came in front of me for what will be the last time now. I've been following the family, 2 little girls, 6 and 7, since they initially entered the system about 3 years ago. The reason that case concluded yesterday, and the last time I'm going to see it, is I got to do the adoption ceremony for them yesterday in my courtroom about 4 o'clock in the afternoon. For them, their adoptive parents, and I think there were about 40 people, family and friends, who'd come to celebrate that event. So we do have those kinds of outcomes. One of the things that we hope occurs in the model that we're using with the one family, one judge, is that those outcomes occur sooner rather than later. One of the criticisms of the child abuse system for a long time has been what they call foster care drift, where children just remain in foster care for indefinite periods of time, and we try to work to bring that to a conclusion as quickly as we can, and yesterday was one of those opportunities to do that.
David Poole, City Club member. My question's about the war on drugs. A lot of opinions out there, and I'm kind of curious from your perspective. You have a unique vantage point on this. Specifically, I guess my question is around alcohol and marijuana. Some of the people that talk about the deaths that are related to alcohol, and you talk about alcohol abuse as a problem. Other people talk about legalizing marijuana and all the great revenues that would provide to our state. I don't really have a strong opinion on this myself, but I'm curious from your vantage point and any insights you've got on that. And actually, as well, the 900,000 cases that you talk about going through the courts, how much of those result from the war on drugs?
Relatively small amount of those cases result on the war on drugs. The issue of legalization of marijuana is an issue I'm going to leave up to the voters in the legislature. The reality has been the last few months, because of the budget issues, that there's no war on marijuana going on. Those are all being treated as violations at this point, just fines. In terms of the alcohol use and abuse, just a couple of things. Drunk drivers kill people. That's a reality. They're some of the most dangerous people in our society. In terms of child abuse cases, almost every parent that we have in front of us in a child abuse case is a substance abuser. And methamphetamines are just an epidemic in our community that is a deadly epidemic to our children. People cannot use methamphetamines and parent. That's just totally inconsistent. Fetal alcohol syndrome. Those children that we see in our system, dependency system, where the underlying problem is fetal alcohol syndrome, are actually worse off than if the parent had been using heroin. In terms of the damage that we see and the likelihood that we're going to be able to have those children, regardless of what services we provide to them in the future, become a productive member of our community. So I think we need to separate the term war on drugs and the recognition that we cannot ignore substance abuse problems, including alcohol.
Muriel Goldman, member of the City Club, but also a longtime child advocate, from the youngest through the juvenile justice system and so forth and so on. I agree with everything you said. However, I'm sure you don't disagree with it, but you can't cover everything. The courts can't do everything. And if you look at the budgets, what they do is they pit one area against the other. And so it's public safety. Currently, the Oregon Youth Authority and what used to be called the training schools are pitted against community services. And you cut one and you don't have the other. I think it's more than just supporting more money for the operations of the courts, but seeing how systems fit together. What can we do as citizens to address that area? Because they tend to say they cut one part and leave the other part. And if you don't start younger, as you said, forget it by the time they get into the juvenile correction system, let alone the adult system.
Muriel, I think the one word answer is revenue. One of the things that we really have looked at as we've been going through this process of the budget reductions is to work together and recognize that we need all of the pieces of the system, including the social service piece of the system, to be effective. I mean, I'm not going to be effective as a judge in a criminal justice system if I don't have mental health treatment out there. If those resources are not available, what's going to happen is that those people are going to come through the system over and over and over again with no improvement. If we don't have substance abuse treatment, if that's not available to the people that need it, then we're not going to be effective. So we are trying very hard not to play one off against the other. One of the things we do with our local public safety coordinating council that Commissioner Nato chairs is to sit down together and work together as a group with the sheriff and the district attorney and the courts, the public defender, the county commission, the mayor, police chief, and others to make sure that we're addressing the system holistically rather than all fighting for our piece of the pie and trying to make our piece of the pie larger. That doesn't do any of us any good.
Thank you.
Thank you.
Andrew Wheeler, member. I was looking at the Brady statistics, and I noted that Canadians have about as much gun ownership as we do, yet we have 78 times the number of capital crimes caused by guns, so that makes me think we're a violent society, and maybe we're finding that out right now. But the other thing I think about is that we have more jail space than the other country, probably in the world, proportionately. So I don't know how you kind of get around those issues. The other thing I think is that a lot of people who are in the penitentiary are there because of drug crimes. Can you comment?
Yeah, I don't have the statistics at this point, Mr. Wheeler, in terms of who's there. In terms of the population, I do agree that there I've read some information to indicate a significant portion of the population in the penitentiaries at least have substance abuse issues, whether the underlying crime that they're there for is a drug crime or not. So I think that's about the best answer I can give you. I don't have an answer to that underlying question.
Is your experience, though, that we're a violent society compared to others?
I'm going to be careful on this because my family's from Canada. I have 4 brothers that live up there right now. So that has not been my experience. I do agree that statistics indicate that we have a higher percentage of our population incarcerated than most other societies. One thing that has been happening for the last few years, though, and we can argue about the merits of certain aspects of the justice system, is that the totality of those has been that up until the last few months, the crime rate has been significantly dropping throughout this state. And the number of filings that we've have gone down. The juvenile delinquency numbers in Multnomah County now are less than half what they were 5 years ago. So there may be some things that we're not doing right, but there are a lot of things that are adding up to a situation where we're living in a safer society now than we were living in 10 years ago.
Nikki Lynch, member, with another question. This is a total divergence from sort of what we've been talking about, and of course in the light of what you're talking about budget-wise, maybe is just sort of a fool's question, but in terms of civil things, it seems to me that, and maybe this is what tort reform is, but that in sort of lawsuit situation where things end up being mediated and people just settle, while I'm a pragmatist, I think that to a great degree people settle when they really should, not settle, because they just a fear of, getting a much less bigger, monetary result. And is that making any sense? You're looking.
Yeah.
And I'm wondering, it just seems like it's kind of we're in sort of where you're in a lose-lose situation, and what answer there is other than more money for the courts.
Well, that's part of the whole process of voluntarily settling your case is weighing your losses. The former U.S. attorney who does a lot of mediation at this point, who's here today, could talk to you about that. It's trading the certainty for the uncertain. And there's buyer's remorse is probably one of the biggest things that you deal with in terms of people in settlement conferences and settling their own cases, because you never know how it would turn out. I will say, though, that one of the components that is absolutely essential to settlement conferences and mediation working is you have to have a court backup. If there's not the possibility that you're going to go to trial within a reasonable period of time, there's a lot less motivation, at least from one side, maybe from both, to settle that case. And we have to keep that. Our goal would be, if we, on any given day, we'd have that one empty courtroom that was sitting there threatening the people that are thinking about going to trial, to give them that option. If they don't want to settle the case and they want to have the trial, here we are. We'll give you the trial. We don't want to discourage you from doing that, but we have to have that option available for them.
Hi, Alex Schreck, City Club. June 5th or 6th, there was a New York Times article that quoted Chief Kroger, and it said something to the effect of, if you can't afford counsel, you're free to go. And I was kind of stunned by that article. Secondly, I read something in the media. There was a judge in Houston, Texas, I think Ted Poe, and this guy had some sort of creative sentencing. He would have, for example, like shoplifters, I think he made them hold a sign and stand in front of the the stores where they committed the crime. So I just wanted to ask you for some ideas on creative sentencing, that sort of thing.
One of the things that goes on in the community court process is for shoplifters, for instance, besides doing their community service obligation, and besides taking a look at some of the reasons that might have gotten them there in the first place in terms of mental health or housing, or as simple as maybe they just need some food bank referral or something like that. It's not unusual there to have part of that sanction to be to sit down and write 100 sentences that I will not steal from Fred Myers again. And that's not an unusual sentence to include that part of it. That's different than holding up the sign, but it's the same general concept. Okay? Thank you very much.
Thank you very much, Dale Koch. It was very enlightening. And next week, Diane Lynn here, Multnomah County Chair. We look forward to seeing you then, and we're adjourned. Thanks.